Get ready for the dictation. Dictation will start in 5 seconds. Start. Mr. Anshuman Kumar, learned counsel appearing for the petitioner, vociferously argues that the impugned orders are not tenable in the eyes of law. Learned counsel further argues that merely on the basis of inquiry report, the punishment was inflicted by the disciplinary authority. Learned counsel further argues that the appellate authority and the revisional authority, without considering defense taken by the petitioner, have mechanically affirmed the order of punishment inflicted by the disciplinary authority. As such, the impugned orders are not tenable in the eyes of law and fit to be quashed and set aside. Learned counsel further argues that the departmental proceeding was conducted ex parte, since the petitioner was not informed about initiation of such proceeding and behind his back the same was conducted. Even the copy of inquiry report was not supplied to the petitioner, and the Superintendent of Police, Dhanbad, merely on the basis of findings returned by the inquiry officer, has inflicted the punishment of dismissal from service, which is a major punishment. Even the appellate authority and the revisional authority have not considered the defense taken by the petitioner and mechanically affirmed the order of punishment by rejecting the appeal and memorial preferred by the petitioner. Learned counsel submits that for the aforesaid facts and reasons, the impugned orders are not tenable in the eyes of law, and the same are fit to be quashed and set aside, and the respondents be directed to reinstate the petitioner into service with all consequential benefits. Learned counsel, representing in the respondent state by vehemently opposing the contention of learned counsel for the petitioner, submits that order of disciplinary authority was passed after taking into consideration the inquiry report. Hence, the same was subsequently affirmed by the appellate authority as well as by the revisional authority. Learned counsel further argues that in a police force, indiscipline cannot be tolerated. The petitioner, who is the member of police force, has remained absent unauthorizedly beyond the period of leave sanctioned in his favor, which cannot be tolerated, and therefore the punishment order is fully justified, which was later on affirmed by the appellate authority as well as the revisional authority. Learned counsel further argues that on 6/1/2023, this court directed the respondents to produce the original file of the departmental proceedings, which they have produced before the court. drawing attention of the court towards the original records of the departmental proceeding relating to petitioner, it was submitted that ample opportunity of hearing has been given to the petitioner, and after following the cardinal principle of natural justice, the order of dismissal has been passed, holding the petitioner guilty of charge. Learned counsel further argues that law is well settled that this court, sitting under Article 226 of the Constitution, cannot reappraise the evidences. Stop.